Good afternoon, everybody. It's 3:30, so we're going to go ahead and get this call started. Thank you very much for joining us. My name is Richard Braun, and I am president of Choice Financial Group. Choice Financial Group is an insurance agency with offices throughout the Mid-Atlantic and clients throughout the United States, and we're the parent company of the Glandon Insurance Agency, which is an employee benefits general agency with brokers and clients throughout the state of Virginia. As you all know, we're living through a period of very rapid change. And as our company was navigating the requirements of the Families First Coronavirus Response Act, we had a lot of questions and not a lot of answers. And we were trying to navigate through those. And we figured that a lot of other companies and brokers that we work with had a lot of the same questions. We reached out to Ann Bebo, who we've worked with in the past. She's an employment law specialist and partner at Vandeventer Black. And she's agreed to go over the law with us and what the employer requirements are of the law and answer some questions. And she did so on really short notice. We only scheduled this call as recently as yesterday. So we put this together very quickly. I really want to thank Ann for putting this together and helping walk all of us through the information that we have. Mark Glandon, our Vice President of Employee Benefits, is going to be emceeing today's call. He'll introduce Ann and present Ann with questions that we've been presented through the registration process. So many of you sent questions in advance, and we are going to make a best effort to get through all those questions at the end of the call. If we have additional time before the call's over at 4:30, we'll go ahead and unmute everybody, and we'll offer up some time for additional questions. We do have a hard stop at 4:30, so if we can't get to some additional questions or get to all the questions that were submitted during the registration process, we will do our best to answer those in an email. Just a heads up, we've already had questions about the CARES Act that was, as you probably know, was just approved today by the House of Representatives and is going to President Trump for signature. And we plan on scheduling another call next week to have an overview of that and inviting some bankers on the call to go over the loan provisions that the SBA has put out. So look for an invitation for that call next week. And thank you again for joining us today. So with that, I am going to pass it over to Mark to introduce Ann and get the call started. And Mark, I am having a hard time finding you on the list of participants. It's so long. Let's see. I'm going to unmute all.
Yeah, can I get the
Looks like I'm logged in as you.
tangy
Mark, what do you want?
burger?
Sure, Mike.
Ann, give me one more second here. There we go.
I'm muted.
All right.
I'm
You're on,
unmuted.
Mark.
Awesome. Well, good afternoon and welcome, everybody. I'm Mark Glandon, VP of Employee Benefits here at Glandon Insurance. We're now a Choice Financial Group company. Choice, in addition to employee benefits, also works with businesses regarding their commercial coverage, individuals, and homeowners. We're very, very pleased to have Ann Bebo with us today. She is attorney and partner, Vandeventer Black, where she is labor and employment law practice group manager. We have received a lot of questions, some of them at the last 15, 20 minutes. We'll try to get to as many as we can. We do have a hard stop at 4:30. However, if we don't answer your questions on the webinar today, Ann has told us that we can submit them to her. She'll try to answer as many as possible, and then we'll get them back out to you. So if Ann is ready, let's get started. Richard, you want to? Okay, there you are.
Okay, I'm unmuted. I think I shared my screen. Can you guys see it now?
I can see you, but I can't see.
Okay.
You probably have to pull that PowerPoint up.
And I've selected, oh, there it is. Sorry, I didn't hit the right button. Is it being shared now?
Yes.
Okay, and let's see, how about now? You have it?
Yep, beautiful.
Okay, wonderful. Well, thank you everyone for joining us. And I really want to thank Mark and Richard for putting this together on such short notice. As Richard mentioned, we just started talking about this yesterday morning. So I was very impressed that the two of them were able to organize this so quickly and get so many people registered in such a short period of time. So thanks to both of them and their teams. I really appreciate it. I've been getting a ton of questions about these laws, and I am also very relieved to hear Richard say that there will be another presentation about the CARES Act. As you're probably aware, it was just passed maybe an hour ago. I have not had a chance to read all 900 pages in the past hour. I've skimmed it, but I am not really prepared to talk about that in any detail today, so I'm very glad there will be a separate presentation on that. I am prepared to talk about the law that was passed back on March 18th, and that's the Families First Coronavirus Response Act. We've had 9 days now to digest it and understand it as best we can. There are still a ton of questions that we all have that have not been answered yet by the Department of Labor. So I look forward to your questions, and I will try to answer them to the extent I can, but please understand that there will be some questions for which I won't have an answer yet, because the Department of Labor is supposed to be issuing guidance. They haven't done that yet. They've issued some information. They have a question and answers page on their website. You need to check it frequently. They don't send out any notice when they add new questions and answers. For example, I shut down my computer at 9 o'clock last night. I woke up this morning at 5 and found that they had added like 15 more questions and answers. So you just have to keep going back and looking. But anyway, the law becomes effective on April 1. And that was a surprise too, because it was signed by the president on March 18th. And the law states that it will go into effect no later than 15 days after the president signs. So we were all expecting it to go into effect on April 2nd, which would have been the 15th day, but the Department of Labor, maybe as an April Fool's Day prank, we're not really sure, they decided to move it up to April 1. So guess what, folks? It goes into effect on April 1 because they get to say. It stays in effect through the end of this year. And what it does is it creates 2 new requirements for paid leave. And this is emergency FMLA. The Department of Labor is calling it extended FMLA, which I think is somewhat misleading, but I think emergency FMLA is a lot more accurate. And it also creates an emergency paid sick leave obligation. What you need to be aware of, which was a huge sea change for employers, is there are a lot of businesses that are not otherwise subject to FMLA who are subject to this new emergency FMLA category. Those businesses don't have any experience applying FMLA, don't understand how FMLA works, and now are going to have to apply it to all of their employees because it applies to businesses with fewer than 500 employees. Regular FMLA only applies if you have at least 50 employees, but this emergency FMLA category applies to any business with fewer than 500 employees. Another huge difference between this and what I'm going to call traditional or regular or old FMLA is traditional FMLA, an employee has to have worked for your business for at least 1 year and have worked at least 1,250 hours in the preceding year in order to be eligible to take FMLA. But under this emergency FMLA, they only have to have worked for you for 30 days, and there's no requirement about the number of hours they have to have worked. So if they work for you for 30 days, they're covered. The good news is that you as a business get to recoup 100% of the paid leave that you provide to your employees, 100% of the paid emergency FMLA and 100% of the paid emergency sick leave. It's going to be done as a credit against your payroll taxes, but it's a refundable tax credit. And that means that if you end up paying more in paid leave than you owe in payroll taxes, you get a refund. You don't have to worry about carryover to the next tax year or any other complications. You're supposed to get a refund. And furthermore, the IRS has said they're going to process those refund requests rapidly, and you can actually apply for the refund before your payroll taxes would be due. So you don't have to wait for that quarterly deadline. You can go ahead and submit with the IRS, showing proof that you incur these expenses, and you'll get a check. That's what they've said. As I mentioned, we're expecting more regulations from the Department of Labor and from the IRS that would clarify the application of both the leave categories and also the tax credits, because we all have some questions about how exactly that's going to work. They have issued the notice. So as with all other federal laws, regarding employees, there is a requirement that you as an employer post in your workspace in conspicuous places where your employees are likely to see it, a poster regarding these two new paid leave categories. And the poster was made available, I want to say it was yesterday, the day before, maybe 2 days ago. It's on the Department of Labor's website. I have the link right there. You can probably get it if you just Google coronavirus, Department of Labor, notice or poster, and it will probably pop up if you don't want to write down that link. But also I'm happy to share these slides with anyone who asks. Anyway, you have to post it in conspicuous places. Now, of course, some people, your employees are no longer at work right now because you may have them teleworking, or they may be out ill or under self-quarantine, self-isolation. You, in that case, would email this to people. If you have people who have been terminated or are on a layoff, you don't have to send it to them. But anyone who is a current employee, you need to share it with them. You can email it to them or you can send it by US mail. Either one is fine. So now I'm going to talk a little bit more about what these leave categories are. So the first one I'm going to talk about is the emergency FMLA. As I mentioned, this applies to any employee that's worked for your business for at least 30 days. And it's basically a new FMLA category. If you are familiar with FMLA, if your business is otherwise subject to it, then you know that FMLA provides for unpaid leave for up to 12 weeks for an employee who needs time off from work because they have a serious health condition, they're unable to work because they have a serious health condition, or they are needed to care for a family member who has a serious health condition. And then there's some special categories of FMLA related to the military and caring for people in the military and military exigencies. But that's the general framework for how FMLA works. This creates a new category, a new qualifying reason for FMLA, and is a qualifying need related to a public health emergency when the employee is unable to work or telework due to need for leave to care for his or her son or daughter who is under the age of 18, if the child's school or child care provider is closed due to a COVID, that's a typo, it's not COVID-10, COVID-19 health emergency. So that's the only reason they would be eligible for this emergency FMLA, is if they had a minor child, son or daughter, who is out of school because the school is closed, or their child care provider is unavailable, is closed because of the COVID-19 health emergency. So for the first 10 days of this emergency FMLA, it is unpaid leave. However, the employee has the option at the employee's selection, the employee's election, not your desire. The employee can elect to use any available paid leave. That could be the paid leave that you provide, such as PTO, vacation, or it could be the emergency paid sick leave, which I'll talk about in a minute. You should hope that they opt for the emergency paid sick leave because you get a tax credit if they do. You don't get a tax credit if they cover those first 10 days with their PTO. But the employee is going to prefer to use the PTO because that's probably going to be 100% of pay, whereas the EP, the emergency paid sick leave, is only going to be 2/3 of pay, as we'll talk about in a minute. But it's going to be up to the employee. After the first 10 days, and the employee could opt not to use anything and go without pay. I can't imagine anyone would do that, but that is their option. After the first 10 days of the emergency paid sick leave, you're going to pay them for at 2/3 of their regular rate of pay, up to a maximum of $200 a day or $10,000 total for the rest of the FMLA period. Now, FMLA lasts for 12 weeks. If your employee, if you are a business that was already subject to FMLA and your employee has used up a portion of his 12-week FMLA allotment, maybe he had surgery or he took time off for a new baby, whatever FMLA he has used is gone. So you're going to take that 12-week total and subtract any FMLA he's already used, because this does not increase the number of weeks of FMLA the employee gets. It's the total of 12 weeks of FMLA for any criteria. So if the employee ends up using part of their 12 weeks for this emergency FMLA to take care of a minor child who's out of school, and then he has surgery, he doesn't get additional FMLA. He only gets that 12-week period. And as I said, there's this cap on the amount that you have to pay the person. You're certainly welcome to pay them more if you'd like to. And I've actually had some clients ask about that. And yes, you can always be more generous to employees than you're required to be. But the only tax credit you're going to get is this 2/3 rate. You're only going to get a tax credit for up to 2/3 of the regular rate of pay. Now, the regular rate of pay is something you may have to give some consideration to. If they're a full-time employee, you're just going to look at what their normal weekly salary is or their normal weekly wages are. If they normally get overtime, you would include that. You're going to look back over if they're an employee who's scheduled for irregular periods, an employee whose schedule fluctuates a lot. Maybe they work 1 week for 50 hours and the next week they only work 20 hours. What you're going to do is average their weekly hours over the past 6 months to come up with the amount that they're going to be owed for each week of this FMLA. If they're a part-time employee, then you would treat just like a full-time employee. How much do they usually make a week? And that's how much their base pay would be, their regular rate of pay would be for the week. And you take 2/3 of that, and that's what they get. So that's the emergency FMLA. And as I mentioned, the emergency FMLA is only available if they need time off because their minor child, their minor son or daughter, is out of school because of the COVID-19 crisis, or the child's daycare provider, child care provider is closed because of the COVID-19 crisis. Emergency paid sick leave is a little different. Emergency paid sick leave is only 80 hours of paid leave, but there are 6 different reasons that the employee can take the emergency paid sick leave. And I have them listed here in this slide. The first is that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. I'm going to pause there because I've received a number of questions on this issue, and I'm sure a lot of you have this question in your minds. I'm going to go ahead and answer it. The consensus is that if you have a governor order, as we've had in Virginia and in North Carolina and a lot of states, if your governor says stay home, that doesn't count. That's not what this is about. A governor's order that everyone should stay home and don't go out unless you have to. And we've seen those orders in California and New York where they really were restrictive and said people can only go out for certain reasons. Those are not the same thing as a federal, state, or local quarantine or isolation order. So that type of order alone would not qualify the employee for these 80 hours of paid leave under Category 1. What we would want to see there is an actual order from a government authority that someone quarantined, and that's really more of not necessarily an individual, but it would be directed to a household or a smaller group of people, but it would be an actual quarantine order, which is a lot different than the stay-at-home orders we've seen from governors, or it would be an isolation order, which again is a very different thing. And if your business has closed because of a governor order that, for example, restaurants in Virginia, restaurants are basically closed now because of the governor's order, that is not a qualifying need under number 1. Number 1 is just if the employee is subject to a quarantine or isolation order, not that the business has been told to shut down by the government. So those types of things would not give the employee leave under Category 1. Category 2 is where the employee has been advised by a healthcare provider to self-quarantine due to concerns about COVID-19. Category 3 is where the employee is experiencing symptoms and is seeking a medical diagnosis. And note, it just says that the employee is seeking a diagnosis. As I'm sure you're aware, a lot of people can't actually get in to see a doctor right now. So all this law requires is that they seek a diagnosis. 4 is if the employee is caring for an individual who is subject to an order as described in 1 or has been advised as described in 2. And the law only says that the employee is caring for an individual. There's no relationship requirement there. It doesn't have to be a family member that they're caring for. It could be their neighbor. It could be their friend. There's no relationship defined there. It's just an individual. They're caring for an individual. 5 overlaps with the emergency FMLA. 5 is the employee is caring for a minor son or daughter because the child's school has been closed or because the child care provider is unavailable due to this crisis. So I imagine a lot of employees will choose to use their 80 hours of paid leave for those first 2 weeks of the emergency FMLA. But again, they don't have to, they can choose not to. However, the Department of Labor has said that they don't get to then add an additional 2 weeks onto their FMLA leaves. They can't take 12 weeks of emergency FMLA opt not to use the emergency paid sick leave for those first 2 weeks, and then after the 12 weeks of FMLA are up, say, now I want to take my 2 weeks of emergency paid sick leave. The Department of Labor has said, no, you can't do that. They can run concurrently, but you don't add on. The maximum is 12 weeks. And number 6 is the big mystery category that we have not received any guidance on. And this one concerns me quite a bit because it really leaves the door wide open. It's for an employee who is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. The Secretary of Health and Human Services has not issued any anything to specify any conditions that would qualify under this. So right now, there are no such conditions, but that could change. I guess just keep looking at the internet to see if something comes up on that. But right now, we haven't seen anything from the Secretary of Health and Human Services. So there is nothing under 6 at this moment. So the pay rates for emergency paid sick leave, there are 2 different rates, and it depends on which category of paid sick leave the employee is taking, which category of emergency paid sick leave. So if they're taking it for the first 3 categories, and that is either a government quarantine or isolation order or a healthcare provider instruction that you quarantine or isolate, or the employee's experiencing symptoms and is seeking a medical diagnosis. So if the employee takes leave for one of those 3 conditions, then the employer must pay those 80 hours of emergency paid sick leave at the employee's regular rate of pay, up to a maximum of $511 per day or $5,110 in the aggregate. And I should say, and this goes for the FMLA amounts as well, the $5,110 in the aggregate or the $10,000 in the aggregate for the FMLA, that's per employee. So it's per employee, it's not on a company-wide basis. Now, if the employee is taking emergency paid sick leave for one of the other 3 conditions, the 4, 5, or 6, the emergency paid sick leave would be paid at 2/3 the employee's regular rate of pay, and up to a maximum of $200 per day and $2,000 in the aggregate. And to calculate those, the employee's regular rate of pay for both of those under emergency paid sick leave, it's the same calculation that you would use for the emergency FMLA. You're going to look at what the employee usually works. Look back to see how many hours does he usually work, what's his usual pay. If he's an FLSA exempt employee, it's much easier. Which brings me to another point I didn't mention before. Both of these paid sick leave categories, both the emergency FMLA and the emergency paid sick leave, they both apply to both your exempt and your non-exempt employees, your part-time employees, your temporary employees, all your employees. The emergency paid sick leave is in addition to any other paid leave the employer provides. So you can't tell the employee you don't get this, you can take PTO, if the employee qualifies, you have to give this to them. And there's no carryover of the emergency paid sick leave. There's no payout of it. If you need to terminate your employee, he doesn't get a check for the unused emergency paid sick leave. It's used for these leave categories, one of these 6 leave categories, or it isn't used at all and it's lost. So one of the questions and answers that the Department of Labor provided sometime in the wee hours of the morning last night while most people were sound asleep was an answer to the question that I've been getting several times over the past 10 days, or I guess it's 9 days, which is what type of documentation can we ask of our employees? Because a lot of businesses are very concerned about the potential for abuse. There unfortunately are employees out there who will look for any excuse for this type of stuff, so much as asking for time off under the emergency FMLA to care for a kid who's out of school when they don't even have a kid. That stuff does happen. There are employees who will do that. So a lot of businesses were asking, what can we ask for? And instead what the Department of Labor said in this guidance was you must require documentation. With other categories of leave, including traditional FMLA, There are certification forms you can use. You don't have to use them. We always advise employers to do so, to use those forms, but an employer can opt not to use it and just tell the employee, okay, you're on FMLA without using the forms. First of all, there are no forms for this new category of emergency FMLA, and the normal FMLA forms have no application whatsoever to these categories. And in the absence of that, what the Department of Labor has said is that you absolutely must require documentation. And the reason why you have to require documentation, you can't just be the nice guy who says, don't worry about it. I know you have a kid. I know that Virginia closed all schools. You're good. Take off for 12 weeks. You can't do that because you're going to be requesting a tax credit. And the IRS wants proof that you are using these payroll dollars for what you say you were using them for. So the Department of Labor has said, and the IRS has said, you're going to have documentation. So if an employee is requesting leave for emergency FMLA or for emergency paid sick leave, you do have to ask for documents. And just as a side note, the employee doesn't have to say, I'd like to request the emergency FMLA. Even though you've put up the notice, the employee is never burdened with having to actually understand his rights. It's your burden as the employer to recognize that when your employee comes to you and says, I need time off because my kid's school is closed and I need to stay home and take care of him, you as the employer are responsible for saying, that's emergency FMLA. Let me tell you about your rights under emergency FMLA. And at that point, you ask for the documentation. And the documentation you can require and should require, I apologize for saying can, the documentation that you must require would be what the Department of Labor describes as the, quote, appropriate documentation to support the reason for the leave. And all they've done is given us some examples right now of what that might be. And of course, it's going to depend on what the employee's reason is for the leave, whether they're falling under the emergency FMLA, or if it's for one of the other reasons for the emergency paid sick leave, depending on what the employee says is his issue when he needs to be out. But at a minimum, of course, the documentation needs to have the employee's name. You need to have some documentation for the qualifying reason for the requested leave. You need to have a statement that the employee is unable to work if that's part of their reason for being out, including telework. Because if the employee is able to telework during an isolation period, for example, then they're not eligible for emergency paid sick leave. The emergency paid sick leave would only be if the employee is unable to work or telework because of one of those 6 categories. And the same with FMLA. If the employee is able to telework from home while caring for the child, then the employee wouldn't be eligible. And then there's a big question about who determines whether the employee is capable of working at home. And I can speak more about that in a minute. But you do need some statement that the employee is unable to work, including telework, and the dates that the employer requested the leave, the dates that the leave will extend for. If the employee is taking time off because of a quarantine order, you ideally would have a copy of that, request a copy of it, at least get the source of the quarantine order. If it was a doctor's order that the employee stay home, who's the doctor? I need a doctor's note. Get something from the doctor to show that that in fact happened. Again, a copy of the quarantine or isolation order. School closure order. Now we all know that the schools in the state are closed. They're closed throughout the country. So that's an easy thing for you to get. Just print it out from the internet, find a newspaper article or the governor's order closing schools, print it out, save it, and then you'll have it for all these requests that you're having to process. If the person is taking out because of a child who is out of school, then you want documentation of the parental relationship. The law just says that the employee can have this time off to care for a child who's out of school or out of daycare. It's only for the employee's son or daughter. Now, that doesn't require a biological relationship. Certainly a legal guardian would work, or it could be a child that you don't have an actual legal relationship with, but you do stand as that child's parent. But they need to produce some documentation of that relationship. And some thoughts I have on this, and this is not in the law, and this is not in the Department of Labor's guidance that we've seen so far. Maybe they'll give us more clarification on it. But some examples that I can think of documenting the parent-parental relationship would be obviously birth certificates or court papers if a person says they're the legal guardian. But another idea would be a tax return. Did you claim this child as a dependent on your tax return? So just give some thought to what documentation the employee could show you to prove that relationship. If they have some documents from the child's school showing that they're the one that the school believes is responsible for the child, that might do it for you. And of course, you need to have some proof of the child's age, which is, birth certificate would be ideal there, because this is only available if they're minors. And the reason you want to do that is there's a risk if you're paying employees this emergency FMLA pay or emergency paid sick leave, and you don't have proper documentation, there's a risk that the IRS will deny your claim for a tax credit. So a lot of the questions I've been getting lately go to, what do we do if we have to trim our staff? A lot of businesses are facing a huge downturn in business. Some businesses are having to close. The luckier businesses are able to keep operating, but they can't pay everybody anymore, and they don't need everybody anymore because business has dropped off so rapidly. So the terms that you hear thrown around a lot are layoff and furlough, and of course, terminations. And we all know what terminations are. I want to speak briefly about just the terminology of layoffs and furloughs, because there's a lot of confusion about that. And I think part of it is because there are different rules for federal employees, and in some states, they have some special rules about these types of terms. But in Virginia and in many states, the term layoff and furlough really don't have a legal definition. There's a way that a lot of businesses tend to use these terms, but they're not really legally significant. So you can use whichever term you like. Either way, if the employee is not working, he's going to be eligible for unemployment benefits. If the employee is not working and other people are, he might have a claim that you selected him for this layoff or furlough for a discriminatory reason, that it wasn't related to economic downturn. So that's just some background about those terms and how they're used. If you are in the private sector and you're in Virginia, you can use either layoff or furlough. The way I have seen the terms used a lot is that furlough often denotes a shorter period where you're going to be calling people back in 2 weeks. For example, if it's a slow period, but business picks up again in April, you put people on furlough for 2 weeks and then you bring them back. Usually furlough, there's it's shorter and you are able to point to a date on the calendar when you think you're going to be able to call people back. Layoffs are more indefinite. So usually when people say layoff, it's we're going to have to let you go. We hope to bring you back. We don't know when, and we don't know if we'll be able to bring you back. That's often how layoff is used. But again, I've seen the terms used different ways as well. I've also seen people use furlough to really mean a reduction in hours. And that's fine if you want to call it that, as long as you're clear with your employees about what you're actually doing. But if you are laying off employees or furloughing them or terminating their employment, they are not eligible for either of these new paid leave categories. They don't get the paid FMLA and they don't get the emergency paid sick leave, because those are leave categories. That's available for people who could be working, but they have a need that keeps them away from work. If you have laid off someone or furloughed someone, they couldn't be working even if they wanted to. It's important that whichever one of these terms you go with, that you have a non-discriminatory method for selecting employees. And if you have any familiarity with employment law or with general just best practices for HR, for human resources, that's true anytime you're making an employment decision. You want to have a non-discriminatory method. And what I mean by that is you want to make sure that you're treating your employees the same without regard to their protected characteristics, which would be their gender, their race, their religion, their national origin, all those non-discriminatory reasons. So that can be particularly important when you're selecting employees for layoff. Now, of course, a good defense to a discrimination claim is always, we had a legitimate non-discriminatory reason for doing what we did. So we laid people off because we had an economic crisis and we couldn't afford to pay them anymore. That's clearly a legitimate non-discriminatory reason. But the question could be, why was I selected for layoff and not him? And what you as an employer want to make sure is that you have the documentation to support why you've chosen who you've chosen for the layoff or the furlough, whichever term you want to use. And when doing that, what I think is the strongest defense you could have is if you have a very objective criteria, such as seniority. We're laying people off. We have to get rid of 10% of our staff. We're going to lay off the most junior people. And so last hired, first fired, that type of thing. It's an objective criteria. It's a yardstick you can point to, and there's no subjectivity to it. That makes it a lot easier to defend, as opposed to, we're going to lay off the people that we think are the best performers. Well, how did you decide who were the best performers? And you can imagine that a crafty plaintiff's attorney is going to argue and possibly be able to show that you were choosing best performers based on evaluations from a manager who was biased against people of a particular race. That's a risk you're going to be taking. It doesn't mean you can't use performance, but if you're going to use performance, you need to be very careful that you have good documentation of that. And also take a look to see, do you have documentation from multiple sources, or are all the negative reviews coming from one person? That's usually not a good situation to be in. And then if you do get to the point where you're able to return employees to work, again, you need to have some non-discriminatory method for how you're selecting who gets to come back when. And just as when it comes to the layoffs, you want the return to work to be ideally based on an objective criteria if you can. If you can't do objective, have some good documentation to support it. A lot of businesses are using skill sets. This type of work has dropped off, but we still have some of this other type of work. So we just need people who can do this other type of work where we still have a need. That's an objective criteria, but just make sure you have some documentation for how you decided who had the correct skill set for the work that you needed. Whichever way you go, it's very important that you give your employees a written notice so that they know what's going on. It helps them in applying for unemployment benefits. If they have something they can show to the Unemployment Commission, the VEC in Virginia, to show that they're not working. It's also just a question of fairness, but it also helps document what happened and when, and that can help protect you as a business. In writing this notice, some things you might want to think about in making this decision that you're going to be laying people off is, do you hope that you'll be able to recall them at some point? In which case, you might want to say that in the letter so they know that you're not writing them off entirely, you hope to work with them again. You certainly would want to put in the letter that we're letting you go or we're laying you off because of this, because of economic reasons. And you can point to the coronavirus problem. I think even in a year's time or 5 years' time, courts are going to remember this. So you would want to highlight that in the letter, that that's why we're doing this. It's because of the coronavirus epidemic and the sudden drop off in our business, and we really don't, we have to cut back right now. If you do tell them that you're hoping to recall them, make sure you're not using any language to suggest that you're promising that. You don't want to have any type of promise to your employees. So I would recommend some vague language about, we hope to recall you when business circumstances improve. If at some point you realize they're not going to improve and you're never going to be able to rehire them, then the proper thing would be to send them a letter telling them that. That's not required, but I think it's really the better thing to do. And it also helps draw out when the relationship was terminated. And in that second letter to them saying, unfortunately, we're not going to be able to recall you to employment, you would also put your employment is terminated effective as of, and then put in their last date of employment. So they weren't employed during that period that they were laid off. While they're laid off, they typically would not be eligible for benefits, but several insurance companies, and I'm sure that Richard or Mark can speak more to this, but several insurance companies have been letting people know that they're going to relax the qualification rules under group health plans, more relaxed now. I'd like to try to continue the employee health furlough, and those are businesses that are really hoping they will be able to recall these people soon. Businesses are trying to do that for their employees if they can. If the employees, if you're going to do that, you want to make that clear in the letter so the employee knows what to expect. If they're not going to be, you should let them know that they will be eligible for COBRA if your business is subject to COBRA. And then what I typically say is you'll receive a separate notice regarding your eligibility for continuation of coverage under COBRA. And then you would send a separate notice about that. Another decision to make is, are you going to pay out their PTO or their vacation? If you're going to do so, let them know. If you're not going to do so, you probably want to state that as well. In a lot of ways, this is basically a termination. So they have all the rights they would have in a termination as well. You do have to pay them through their last day of employment, obviously, so let them know when to expect their final paycheck. One other consideration, and this would only apply if you have more than 100 full-time employees, is take a look at the WARN Act. This is a federal law that requires businesses in some circumstances to issue an advance notice of a layoff or mass termination to employees. It would only apply, again, if you had at least 100 full-time employees, and it would only apply if you were laying off at least 50 full-time employees. And then there are a number of other details with the WARN Act. So if you have questions about that, that's something you need to pursue. But just keep that in mind, that that might be something that could apply to you if your business is large enough. One other just note, if you you should definitely take a look at any state leave laws that would apply to you. If you're in Virginia, we're fortunate in that we don't really have any other laws, but there are some states that have some paid leave requirements for employees, and they also have some requirements about paying out vacation, and they have requirements about when you have to give employees their final paycheck. So just take a look at your state's laws if you're not in Virginia. And I'm just going to go over this briefly because I see we're running low on time, and I want to make sure we have sufficient time for questions. You should, if you don't already, you should put together a coronavirus policy and have a plan. It's very important that you let employees know who they should contact if they are ill or they have been exposed to someone who is infected. What you don't want is employees calling various supervisors and various managers, because that's going to lead to a chaotic response from the company, and it will just flame the rumor mill and lead to a lot of problems for you. So designate a single individual or one individual per office if you have multiple offices, but tell them who to contact. Tell employees that they've been exposed to someone who has tested positive, they need to stay home for 14 days. If you have employees that show up to work with a bad cough and a fever, send them home. Absolutely send them home. Make sure your employees know, don't come in if you feel sick. Don't come in at all. Make sure that's very clear to your employees. The CDC's guidance about employees who have exhibited symptoms is that if they go 72 hours without either medication or fever, they're okay to come back. So that's all the information that we have at this point. And I have that up there on the screen. At least 72 hours have passed since recovery, and at least 7 days have passed since the symptoms first appeared. So if they meet those criteria, you can let them come back. Of course, if they present a doctor's note, I would say let them come back. There have been some mixed reports about whether a negative test result indicates that you're actually free of the virus. I'm not a doctor. I'm not sure how accurate that is, but so just take a look at the CDC website on that. And some other things, certainly make sure you have a policy and practice of frequently disinfecting touch surfaces, enforcing social distancing at work, banning meetings of more than 10 employees. If you're subject to any government stay-home order, by all means comply with it. Take a look at if any of your employees can telework, and if so, let them do that if you can. And I understand that's not possible for all businesses. One thing just to give some thought to, if you're sending non-exempt employees home to telework, you need to be a little more careful than you would with your exempt employees. Under normal circumstances, when we're not in coronavirus land, I would always say, don't let your non-exempt employees work at home, because how do you track their hours, and how do you defend against an FLSA claim that they were working overtime? These are extraordinary times we're living in, so a lot of businesses are allowing non-exempt employees to telework. If you're going to do that, come up with a procedure that you can document their hours. One idea is to require the employee to check in at the beginning when they first start working, to email their supervisor, I'm online, I'm at work now, and when they're done, to email their supervisor with, I'm checking out now, I'm done for the day, and listing what they did that day, so you have some record of what hours they worked and what they actually did, in case they later say, I was working 15 hours a day, and you knew it. And then, of course, you want to have a plan for what to do if an employee tests positive. You should be aware that OSHA does consider this a reportable event. So if you have an employee who tests positive, you do need to report that to OSHA. And these are just some questions I had put up that I've gotten a lot, but I can skip that and go to the questions that Mark and Richard have actually received. I can leave that screen up though if people want to reference those. And then the final slide I have is just a link to my firm's website. We have issued a number of articles about this whole COVID crisis, not just employment law issues, but other resources for businesses about various legal issues that have come up because of this crisis. And I encourage you to look at that website because we've got a lot of very good, useful information there. So I'm going to leave up my question slide and turn it over to Mark and Richard to see what questions people have.
Okay. Well, great presentation, Ann, and I think you've answered a lot of them during the course of the presentation. So I'm going to start with this first question. It says, health insurance is mentioned as being included in the relief available to small employers through the payroll tax subsidy. How is this accessed and what part of the total premium is included? Employee contributions, employer, or total cost?
Okay, that's part of this new CARES Act. I haven't been able to read the act, as I said, it was just passed an hour ago. So I encourage you to look into that. And the next webinar that Mark and Richard are presenting should address that issue for you. But the last draft I looked at did say that there was going to be some relief for businesses to cover that cost.
Okay. Next question says, our division has 5 employees. However, our parent company has over 500 employees. How will the stimulus package affect us? Sounds like another CARES Act, but.
Well, it also has some
Yeah.
application. It has some application to the Families First Coronavirus Response Act paid leave, in that those only apply if your business has fewer than 500 employees. So if you are part of a larger organization that has more employees, you're going to have to look to whether or not you are in a joint employment or integrated employment status. And those are separate tests. And I was a little surprised at this, that the Department of Labor decided to go with both tests, which leads to a lot of confusion. And what they've said is, with regard to the emergency FMLA, we're going to use the integrated employer test, which is a test that arises from FMLA. And with regard to the emergency paid sick leave, we're going to use both the integrated employer test and the FLSA joint employment test. So those are 2 separate tests, and they're rather complex, but basically both tests look at whether or not 2 businesses can be combined for purposes of adding all the employees together and coming up with a larger head count. And that's going to depend on the amount of control that both businesses have over the employee, to what extent both businesses can direct the employee's work, who controls the payroll, who controls the employment records, but they're kind of complex tests. So that's just kind of a flavor of what the answer would be.
Next question says, is a local government considered a small or mid-sized business? This particular county, we employ approximately 160 total full-time and part-time employees.
Yes, they are subject to both of these laws, to both these paid leaves, emergency paid sick leave and the emergency FMLA.
Would you please clarify if an employee is furloughed before April 1st, if they are entitled to any benefits?
That one I actually have an answer to. That's an easy one. No, they are not entitled to any of this. If they get furloughed prior to April 1, they don't get anything. And after April 1, if you furlough them, they don't get anything after that date.
Okay. All right. So I think you answered this one, but I'm going to go ahead and ask it just because somebody probably is out there wanting you to specifically address it. But it says, if we shorten our work week to a drastic decrease in due to a drastic decrease in business, and we have always had our employees use their paid leave, if it is available before timeout without pay, can we ask them to defer their paid leave for later when our business is better?
I'm not sure I understood that. Can you say that one more time?
Yep. If we shorten our work week due to a decrease in business, and the policy has always been that we have our employees use their paid leave if it is available before timeout without pay,
Mm-hmm.
can we ask them to defer their paid leave for later when business is better?
Yes. And and I'm really just speaking to employers in Virginia. There may be some state law implications if you're in a different state, but in Virginia, you can do that. Federal law allows you to do that as well, but some states have extra protections for their employees. I would recommend that you make it clear to employees that you're changing your policy because of the current economic crisis. Issue them a notice that, and it could be something along the lines of, due to the current economic crisis, from this day forward, use of paid leave is temporarily suspended. Something along those lines. I mean, you would want to make sure it was clear that they could still use these federally mandated emergency FEMLA and emergency paid sick leave, but you can tell them that our company provided PTO is no longer available.
Okay. All righty. And then 2 more questions on that. Is there any type of pushback that we as the employer can implement to make it more difficult for employees to take? And I guess they're referring to either the FEMLA or the emergency leave.
Well, you can't prevent them from using the leave if they qualify. I think it is somewhat of pushback that you can and must require them to submit documentation. But beyond that, I wouldn't recommend you do anything beyond requiring the documentation, because they are entitled to this leave, and if you're not giving it to them, you're in violation of the law.
All right, one more question in regards to that. If an employee, and can you hear me okay, Ann?
Yes.
Okay. All right. If an employee, if an employee takes 2 weeks of paid sick leave because they're experiencing COVID symptoms and seeking a medical diagnosis, and the medical diagnosis comes back that they do not have the virus, can the employer deduct the time they took off from their accrued PTO?
No, you should still use the emergency paid sick leave, because all the emergency paid sick leave requires is that they experience symptoms and they seek a medical diagnosis. It doesn't require that they actually test positive. And it's to your benefit to use the emergency paid sick leave because you get a tax credit for it. You don't get tax credit for your PTO.
Are small employers with less than 50 employees exempt from EPSL or the emergency FEMLA?
No, they are not. They are subject to these laws. There is a provision under the law that a business may apply for an exemption if they can prove, if they have less than 50 employees, and they can prove that using this, granting this type of leave would threaten the existence of the company as an ongoing concern. And that's going to be a very steep hurdle for employers to clear. We don't have any further guidance from the government about what you will have to prove, but I'm sure it won't be easy. So I think you should plan to comply with this. I have spoken with a couple of businesses that are in such dire straits right now that they are looking at whether they could do this if they were to try to keep their doors open. So you need to start, if that's the situation you're in, you definitely need to start putting together a good business case that you would have to show to the government to prove why you can't do that.
The next question, is the 2/3 pay a requirement or employer option? Can the employer opt to pay 100% provided the $200 a day and $10,000 max are not exceeded?
The employer can pay more, but they're only going to get a tax credit for the 2/3.
All right, next question says, if an employee receives a car, phone, or other allowance, are those allowances added to the employee's pay to determine the average?
They should not be. I have not seen any guidance on it, but I'd be very surprised if the Department of Labor took that position.
All right, this one is regarding the FEMLA. What if the other parent is also telecommuting? 2 parents are now at home. Does the employee still qualify for the emergency FEMLA?
I've had a lot of questions with that exact question. First of all, if the employee is able to telework, they don't get the emergency FEMLA. The emergency FEMLA is only available if you're unable to work or telework. So if the employee is able to telework, they don't get it. But let's say you have an employee who wants to take the emergency FEMLA to take care of a child, and you know that the other parent is also home. Can you deny the emergency FEMLA? I haven't seen anything from the Department of Labor on that. But the way traditional FEMLA works is it is irrelevant that there's another adult available to care for the child. Under traditional FEMLA, we would often see this question of, an employee asks for time off because their child has a serious health condition and the employees need to care for the serious health condition, and the employer says, but wait, isn't your wife a stay-at-home mom? Can't she take care of Junior? And the Department of Labor has said it doesn't matter. The employee gets to take the time off even if wifey is home and can take care of Junior. The employee can take off too. I think that's how this emergency FEMLA would be interpreted as well, but that's just based on traditional FEMLA. We haven't seen the Department of Labor answer that question yet.
All right. What is the value of telework to wages? In other words, if the employee isn't able to work at 100% when teleworking, can the EPSL be used to compensate the difference?
Well, if they're able to telework, then they shouldn't be getting the EPSL. If you have made a determination that they can accomplish a portion of their job from home, but not the entire job, then I'm not sure if you could then say that I guess you could say that they're on leave for part of the day. And for that part of the day, they would be eligible for the 80 hours of emergency paid sick leave. I suppose that would work. Or actually, that would be, yes, for the emergency paid sick leave or the emergency FEMLA, if they're only able to work for part of the day.
Okay, and then lastly, because I think you really have addressed just about everything, somebody wants to know who pays for all this?
Ultimately, the taxpayers, because it's a refundable tax credit. So this is part of that mushrooming federal debt that we're watching. This is a huge deficit, and us and our great-grandchildren will be paying for this.
Okay. And probably great-great-grandchildren. All right. Well,
Yes.
thank you so much. It was a lot of information. You've digested a lot in this last week, clearly. You've done your homework. We will put out the PDF of the PowerPoint with your permission.
Sure.
And there may be a stray question or two that we didn't address. If we didn't, we'll try to get it to Ann. But again, thanks so much for your time, Ann. Really appreciate it. Thanks to everybody that tuned in, and be on the lookout for another webinar next week, hopefully, regarding the CARES Act. And I'm sure an hour is not going to be enough time to address that. But anyway, thanks so much. Thank you, everybody, for tuning in, and stay safe. Have a great weekend.
Thank you very
Ann.
much.
Thank you.
Bye.